I'm Chris Cumberbatch, Senior Associate at Ashtons Legal in the French Legal Services team. So, do I need a French will or an English will in England if I've got French property? The question has been posed and not really definitively answered by both French and English lawyers. Since EU succession regulation, it's quite common to have French notaires decide that, well, they'll just bounce the will back to the English lawyer. But in practice, that's not always the best idea. The EU succession regulation does allow you to choose for English law to apply to your French property based on your nationality, but that's not always going to be the best thing for you to do. There's no one size fits all. If you have an English will dealing with your French property, you may have to wait until probate is dealt with before you can deal with that property. And there are strict time rules for the payment of taxes in France. Any delays can cost money. Also, some things get lost in translation. If you have an English will that contains, for instance, trusts, trusts are notoriously thought of badly in France due to the Napoleonic Code. And as a result, you may end up paying much more tax than you anticipated. Equally, there are things that are faux amis, one might say, and usufruit is often described as being similar to a life interest. However, it's taxed differently in France and the UK, so you may get advice that an usufruit in your will would be a great idea, and that would be the case if you were living in France, but it might not be the case if you're also in the UK. On the subject of inheritance tax, bear in mind that in the UK we tax people based on the overall estate. So the net estate is calculated and then divvied up between the beneficiaries. So it's more akin to an estate tax. In France, it's a real inheritance tax per beneficiary. So if you, for instance, decide that you want a beneficiary to receive a legacy without paying tax and you stipulate as such, that doesn't really work under the French system. They have to pay the tax. So in effect, you're giving them a legacy on top of what you thought you were giving them. These kinds of complications your executors could well do without. So I suppose the broad advice is don't consider that one advice will fit all. Everything has to be done on a case-by-case basis, and always take advice. In the UK, we have what's known as the 7-year rule, and inheritance tax is pretty arcane. Most people don't know much about it, but the 7-year rule is something that a lot of people will be aware of. You give something away, you survive 7 years, great, there's no inheritance tax on it. We don't have that in France. There's something known as droit de donation, so gift tax, and you have to pay the tax on the gift within a short period. Set time frames apply. So you've got to be thinking not just about what the French rules are, but also the English rules at the same time. Helpfully, at least the droit de donation mirrors the tax rules on death. So if you already know what the taxes are likely to be if you die owning the asset, then if you decide to give some away, well, you can follow those rules without having to work up a second set of calculations. So for instance, if you have a property worth a couple €100,000 and 2 children, you could give that away straight away with paying no droit de donation because the exemption is €100,000, just as it is if you die owning that property. However, we're then back into the English side because if you die within 7 years of making that gift, and let's say for argument's sake that the property wasn't worth a couple €100,000, it was worth €400,000, you've taken a hit and paid some tax there and then, thinking that would be the end of it, but you pass away within 7 years, you're going to have to pay inheritance tax, or at least it's going to affect the inheritance tax payable in the UK. But because they're different taxes, droit de donation and inheritance tax, they're not covered under the double tax treaty, so you won't get any tax relief. You end up paying both taxes, which is the worst case scenario. If you're going to be giving a property away, you've also got to think about capital gains tax. Now, there's no capital gains tax in France on gifts. I mean, that makes sense. They pay gift tax on gifts. But in the UK, you'll pay capital gains tax on gifts. And that in and of itself can be quite significant. So you have to do those calculations, and again, you're not going to be getting double tax relief between them. Moreover, and this is a planning point regardless of where you're resident or where your assets are held, if you pay your capital gains tax on your gift and then you die within 7 years, again, you get no tax relief on that. So the advice has got to be case by case. Consider your tax position in the round. Don't just think about what's going to be good for you from a French perspective or an English perspective. Take advice, both sides, and preferably from someone who understands both sides of the channel.